Okay, criminal defenses. Maybe we'll make it through the rest. Maybe not. We'll see. Categories of defenses. We have failure of proof, which means defendant asserts the prosecutor failed to prove an element. So no element, done. Justifications, D acted properly, so no societal harm. Excuses, D acted improperly, but he's not blameworthy for various reasons. And then we have public policy defenses, which we actually didn't learn. Privileges, immunities, statute of limitations. So, justifications. I did it, but I was justified. So, we have a few, and they are self-defense, defense of others, defense of habitation and property, law enforcement defenses / crime prevention and arrest, and necessity. Those are our justification defenses. So, self-defense. Common law says one may use reasonable force to protect oneself if he reasonably believes it is necessary under the circumstances. Model Penal Code excludes the word reasonable here, but might find that the defendant guilty of reckless or negligent if belief was reckless or negligent. There's exceptions. Self-defense may not be used by the aggressor or one who provokes the attack. So our cases tended to show like how this could be fuzzy, like where did the attack begin? Who was the aggressor? When did it start? And then the aggressor, though, may regain the right of self-defense if he communicates to his adversary his intent to withdraw and in good faith attempts to withdraw. Defendant may claim self-defense if he arms himself in order to proceed upon his normal activities, even if he realizes that danger may await him, but not if he arms himself for an unlawful purpose. This turns on D's intent. So if he's arming himself for self-defense, fine. If he's arming himself because he's not going to let anyone tell him he can't walk in the street and he's going to take care of it, not going to work. And then we have the use of deadly force, no deadly force unless necessary to propel a deadly attack and risk imminent death or serious bodily harm. In the common law model penal code, but the minority rule, you have a duty to retreat. Duty to retreat to the wall rather than use deadly force. This is not the case if it is your own home, even in the minority common law and MPC. And MPC actually says in the workplace, it's also fair game. And they also have an exception that if to retreat would be dangerous and you have to do it, then you can do it. But the majority says stand your ground. Defendant may stand your ground and use deadly force if necessary. As we know, public policy has been weird about this in the recent years. And then there is imperfect self-defense. In some states, including California, a good faith but unreasonable belief that deadly force was necessary may yield a manslaughter verdict. So it may not get you off. Defense of others. May use reasonable force, including deadly force, in defense of others when the person defendant is acting to, defense of others. So if you act to defend someone else, and it would have been justified for the person to defend themselves in that way, it will be generally justified for you to defend them that way. But if you defend someone because you think they are being victimized, and then you find out that that the defendant was the aggressor, and the person you were helping was the aggressor, then the common law and the minority rule uses the alter ego rule, and it says D steps into the shoes of the person he is defending, and he loses the defense if that person could not have acted in self-defense. But the majority rule, thankfully, says defense is allowed if D had a reasonable belief aid was justified. And then defense of habitation and property. Reasonable force may be used to protect property, except Deadly force may not be used except that one may use deadly force against an intruder in the home to prevent a violent felony. Some jurisdictions extend the right beyond the threshold so that you can pursue. Some do not require reasonable belief the victim intends a felony. And then this is distinguishable from self-defense. Defensive habitation does not require imminency. So some, and this wasn't in any of his stuff I just read, some require a warning, which would mean you had like back and forth moments, but it's still a reasonable belief that something's going to happen. Reasonable force may be used to protect from property. And then you have law enforcement defenses, crime prevention, and arrest. The majority says deadly force may only be used to prevent violent felonies or apprehend violent felons. So this is for police. And then most jurisdictions do not extend this to private citizens, but as we know from horrible recent years, sometimes the only thing that can stop a bad guy with a gun is a good guy with a gun, whether you believe that or not. That has happened, and I don't believe those good guys with guns have been charged. So reasonable force is the standard here. And, oh, okay. So next is necessity, and necessity is going to go right into our next excuse defense. Necessity. Unlike other defenses, here the victim is an innocent party whose property can help the defendant avoid harm. So in necessity, you have someone who has injured another or property as he tries to protect himself. In all other justification defenses, the victim is the aggressor, but not so here. So here's an elements test, and there are a lot. So the defendant faces a choice of evils or harms. There are no lawful alternatives to avoid the harm. The harm threatened is immediate. The defendant reasonably chooses the lesser harm. The defendant did not create the necessity. No specific legislative or judicial decision to the contrary. So those are the main things. And then we've got some caveats. This isn't a defense for murder, except under the Model Penal Code. Weird. Economic necessity alone cannot support a crime, but Model Penal Code, no such limit. And some jurisdictions say risk must be from natural, non-human force. And then we have, those were our justifications, which are self-defense, defense of others, defense of habitation and property, law enforcement defenses, and necessity. And then we go to excuses defenses, which are I did it, but let me make sure I'm saying that correctly, because I feel like I may not be. Acted improperly, but is not blameworthy. Okay. So justifications is I had a reason to justifications is I did it, but I was justified. Excuses are I don't bear the blame for this. I did it, but I'm not blameworthy. So excuses are duress, which we're going to talk about first, because duress and necessity are going to be used. You're going to look at both of them when you're looking through that lens. And intoxication and insanity. Okay. So once you've looked at necessity, you're going to look at duress. Duress does not include threats to property, but necessity does. So if it's just property, you're going to go to necessity and see if it works. Duress is also an elements test. Also is not a defense to homicide. It does not say that we're limited. The MPC does not say that it is different. So for duress, it won't be a defense for homicide. Okay, so duress. The elements are an imminent threat of death or serious bodily injury against the defendant, a relative, or close friend, The defendant has a well-grounded fear. The defendant did not put himself in that position. The defendant has no reasonable escape. So, imminent threat of death or serious bodily injury against the defendant, a relative, or a close friend. The defendant has a well-grounded fear. The defendant did not put himself in that position, and he has no reasonable escape. Again, not a defense for homicide. So that's duress. And then we have intoxication. You cannot commit a specific intent crime if you are intoxicated. Specific intent crimes are first and second degree murder or burglary. Reread statute that's given to you for the exam to see what intent is being asked for. If it's specific intent and they are intoxicated, they cannot be charged with it because there's no specific intent if you are intoxicated. For general intent, voluntary intoxication is not a defense, except common law says may negate specific intent but not general intent. Model Penal Code says a defense to crimes requiring purpose, not those requiring reckless or negligence. So if it requires purpose, you're not going to pass for the Model Penal Code, but you can get reckless and negligence, so you got to look at the statute. Remember, if statute doesn't say mens rea, then it is purposeful and knowledgeable, which is specific intent. And involuntary intoxication is a defense. Because if you didn't mean it, then it's almost like it's not a voluntary act at all. So, insanity. A defendant may be able, this one we have got a lot of tests, so get ready. Insanity. A defendant must be able to tell the difference between a judge and a grapefruit. That's important to know. So they ask the questions, can they understand what's going on in trial, and can they assist in their own defense? Not guilty by reason of insanity means the defendant is committed, and often they are committed for a long period of time until they are deemed not to be a danger to society. Traditionally and generally, insanity was an affirmative defense, but traditionally, when the defendant raised the defense, the prosecutor had the burden to prove that the defendant was sane, sometimes with the burden of proof being the preponderance of evidence. The person who tried to assassinate Reagan is still mentally committed, trying to get out, still committed. So we have we've got 3 tests and some caveats for our insanity, and you're going to have to go through all of them unless he gives us the jurisdiction. The M. Naughton test, approximately 30 states, so the majority. The defendant was laboring under such a defective reason from disease of mind that he did not know the nature and quality of the act he was doing, or he did not know what he was doing was wrong, legally or morally. Did the defendant know what he was doing would generate public condemnation? So this test focuses on the knowledge and the cognitive aspect. Did he know the nature and the quality of the act he was doing, and did he know what he was doing was wrong, legally, morally? So those are the 2 questions you need to ask for the M. Naughton test, but most states apply the irresistible impulse with the M. Naughton test. Coaches generally put these together, but in CA we do not put them together. And it says, did he know the nature and quality, or, this is an OR test, did he know what he was doing was wrong, and did he act on an irresistible impulse? I don't know if that's an OR test. It says plus, so it needs to be and. Irresistible impulse or control test. Did the defendant act with an irresistible impulse? As seen above, generally this is combined with the M. Naughton test. And then we have the product Durham test, and this is only in New Jersey. Did the defendant's unlawful act, was it a product of mental disease or defect? When the class talked about it, it got real weird with, like, what is disease, defect, what is mental illness? Like, how do those words work together? Scary for juries. And then we have the model penal code. Did the defendant, as a result of mental disease or defect, 1, lack the substantial capacity to appreciate the wrongness or criminality of his contract, or lack the substantial capacity to conform his conduct to the requirements of the law? So that's model penal code. So the main ones are the M. Naughton. The caveat is the irresistible impulse. We have the Durham test, and we have the MPC. And then we also have Delphic decree cases. The defendant may be found not guilty by reason of insanity if they honestly believed God told them to commit the crime, even if they know that it is legally wrong and is condemned by society. So they think they're acting for the greater good. Delphic decree cases. You're still going to go through all of them, though. And then you're also going to say it's a Delphic decree case. So many jurisdictions will say mentally insane. All right, we're going to do the inchoate and an accomplice in the one last video.